Well, good morning, everyone. This is George Spees with the Pennsylvania Office of Open Records. I'd like to welcome you to this morning's webinar, where we're going to talk about basics of the right to know law. A couple preliminaries to get out of the way before we get started. First is that all of our webinars, the PowerPoints that we use, are on our website. You go to the main training page, click on that, and scroll down a little bit, and you'll find a list of all the PowerPoints, which you're welcome to download and use at your leisure, whether it be for simply reference or any of your own training programs. They are considered public records. Also, these sessions are recorded, as you can probably note with the banner on the screen. So if one of your colleagues or yourself would like a recording of this, what you can do is mail us a flash drive with a note in a self-addressed stamped return envelope. And turnaround's usually about a week. We would love to be able to email them to you, but the attachments are so big that they don't make it through our email system and the security protocols. Same way with trying to post them on our website. The files are just too large and unwieldy. We are looking into a file sharing service where maybe we'll be able to just send you a link and you can access them, but that's in the future right now. And again, because of the Commonwealth's email system, they have some issues with file sharing services and the possibility of the systems and networks getting infected with viruses. So for now, we use the flash drive system, and that seems to be working fine. Like I said, feel free to send us one with a note if you're interested in any of our recordings for these webinars. If you have any questions, you can type them in the chat feature, and I will do my best to answer them as we're going through the presentation. A couple things, though. First is that, we are talking about basics of the right to know law, so I would ask that you keep your questions on point. More importantly is that try to keep your questions brief. Occasionally someone will type in, several paragraphs, and it's just awkward for me to sit here and have to read through those while everyone's waiting. If it looks like your question is, unusually complex or just specific to your situation, we'll do one of two things. We'll either wait until the end of the presentation and I'll attempt to come back to it, or we can take the conversation offline. I mean, the office phone number and our website URL are on the screen right now, and we're more than happy to take your call, or go to the website and there are email accounts where you can send us your message. More than likely, you'll be put in touch with me, and we'll try and get you steered in the right direction with that. Okay, so all of that being said, let me get a sip of coffee and then we'll dive into this. Okay, what is the right to know law all about? From our perspective, here at the Office of Open Records, it deals with access, transparency, and good government. And it's important to know what the purpose of the right to know law is, because it surprises me, after 12 years of having this law on the books, there's still a fairly good amount of misunderstanding as to just what the intent of the right to know law is. And I say that not only from the public's perspective, but it's surprising how many agency people I talk to that, just haven't taken the time to look at the law and understand what it entails. So here's a fundamental statement that I like to begin the presentation with. The purpose of Pennsylvania's right to know law is to give the public access to public records. Okay, seems like a no-brainer, but you'd be amazed how many people think like it's the state's version of Google, and they can write a right to know request with, any number of questions or inquiries on it, and it's our job to run around and find them the answer. Sometimes those questions have nothing to do with the operations of government. It's like, Google, like I said, and it can be kind of entertaining sometimes with some of the questions that we get. But if you're working on the agency side of the equation and you find yourself kind of stumped or just not sure how to proceed with something, I recommend coming back to this fundamental statement. Okay, this person who submitted the request more than likely has a problem. And they're not sure how to solve the problem, but they think that it might involve a record that we have. All right, how do I address that? Do we have the record, and how do we proceed? And I think that helps you kind of get back on track to find your way and kind of get you started in the right direction with any situation that you might be dealing with. Now, with the right to know law, there are some things to bear in mind that are very important from the agency's perspective. The starting point is that every record of an agency is presumed to be public, meaning if you have it, that's your starting point. It is a public record. And if you're uncomfortable, if you just have that sense that, I'm not really sure we should be releasing this, there is a chance that there is some clause in the right to know law, what we call an exemption, or perhaps there is another law that deems this record as confidential. But in order to support that feeling that you have, that maybe we should withhold this, it is the agency, not the requester, but the agency that bears the burden of proving legally and factually that the record is not public. So you can't just say, I don't think we should give this out. Rather, you have to make a legal and factual case as to why you believe this record should not be released into the public domain. Because remember, your starting point is that it is a public record, and you bear the burden of showing why it should not be released. Okay, two very important points that are really the fundamental, what I'll call the foundation of the right to know law and how it works in Pennsylvania for both state and local government entities that are subject to the right to know law. The other thing that I want to emphasize is that the right to know law is not a confidentiality law. First, there is nothing in the right to know law that prevents an agency from simply giving out public records. I can walk into your office, let's say you're a township and it's budget time, and I can ask for a copy of the budget. And let's say the agency has a stack of budgets sitting there. Nothing in the right to know law prevents that employee from simply handing me a copy of the budget. I don't have to submit a right to know request. Now, the agency can require that I do that. They have the discretion to require that I do that, but they don't have to. Okay, they can simply hand me a copy of the budget. I'm a happy customer. I go out the door and the agency can get back to the important business they were doing before I interrupted them. As a matter of fact, let's say I have a right to know request and I'm asking for a copy of the budget. That public employee can say, George, you know what? If you tear up your right to know request, I'll simply hand you a copy of the budget because it would save me a lot of time and paperwork, and it would also save you some time. What do you say? Well, why wouldn't I do that? Because I'm getting what I want, okay, the copy of the budget. And it's not a violation in any way of the right to know law to do that. And we don't take it personally if you say, tear up that right to know request, as long as everyone's satisfied ultimately with what's happened. Now, if I would say, no, I want to follow the right to know law process, well, then the agency has to. The agency's obligated to do that. Now, what I would suggest, and this came up twice this week, is that look at your right to know requests. Take a look at what people are asking for. Identify the trends, if you will, and take those records that people are requesting and put them on your website. Okay, maybe, if you have a website, most municipalities do. And then next time you receive a right to know request, your response can simply be, that's on our website. Here's the URL for it. And after that website's up a while with all these records that people typically request, you'll notice that the right to know requests start going down as the hits on the website start going up, because suddenly your website is no longer like a billboard, but rather it is a business platform. And we really recommend that. And our experiences with agencies that do this, they really are experiencing good results. A lot less work on the right to know side because everything's already out there. And most residents would rather sit in the comfort of their family room, scan your website, find the document that they need, download it, rather than maybe have to take off an afternoon from work, come down to the office, submit a right to know request, and potentially wait up to a month before they get the records that they need for the problem that they have now. So I'd suggest that you give serious thought to this. Take your most commonly requested records, put them on your website, and that really will save you a lot of time and effort in the long run. Okay, so the agency is subject to the right to know. Oh, question has popped up here. All right, we got a long one. I provide treasurer's report at each township monthly meeting showing salaries of the roadmaster road workers. Chairman, supervisor is the roadmaster wants the salaries to darken out. Is this valid? No. The salaries of public employees are considered a public record. I mean, that's fairly basic. We have a right to know, taxpayers have a right to know how much we're paid. As a matter of fact, for state employees, there is a website called PennWatch, which in addition to a bunch of other records like I was talking about, lists the salaries for every state employee because that is a public record. So unfortunately, your roadmaster's out of luck there. His salary is a public record as far as the citizenry is concerned, okay? All right, good question. Back to agency obligations. Your agency is subject to the right to know law, so there are some things that you must do. First and probably most important is to appoint an agency open records officer, or what we call an ARO. This is the person legally responsible for receiving right to know requests, for processing them, and ultimately for responding to them. Now, there's no requirement other than it be a public employee or a public official. Okay, it can't be like a volunteer, all right? There's no limitation on who this person can be within the organization. It could be the township secretary who greets you when you walk in the door. It could be the school district superintendent who's at the top of the food chain, all right? And we see this all over the map, okay, and that's fine. There's no limit to how many right to know officers or how many, and I interchange those two terms. They mean the same thing. There's no limit as to how many AROs you can have. It's just that you need to look at this from the public's perspective. I need a record. I've got this form. Who do I give it to? Make it as easy as possible for them to know who do they give this right to know request to. The person doesn't have to be sworn in. They don't have to be voted on by council or anything like that. It's just considered a work duty. All right. And it gets added to whatever other duties that this public official or public employee has. Yes, it can be a solicitor because a solicitor is considered a public official in Pennsylvania. Agencies can come up with their own rules for administering their right to know program, and many do. Quick example, the right to know law says that an agency can accept anonymous requests. Okay, there's another law in Pennsylvania called the Statutory Construction Act, where because of that word, or I'm sorry, it says may, it doesn't say can, it says may. And because that word may is in there, it also means may not, okay? So under the right to know law, an agency has the discretion to either accept an anonymous request or not accept an anonymous request. They can pass a policy or invoke a policy that basically says we will only accept right to know requests where the person is identifying themselves. And we have, a history of final determinations on our website where you can see where we've ruled where agencies have invoked that policy. It's entirely acceptable. It is consistent with the right to know law and consistent with all rulings coming out of the Office of Open Records. And if you take a look at the law, you'll see that there is a lot of opportunity for local policies and giving you the flexibility to administer your program as you deem necessary, like I said, as long as it's not in conflict with the right to know law. You can come up with your own form, and many agencies do. They like to have their seal at the top, contact information for the arrow. Maybe they list any of those local rules that they have. But you must also accept the uniform request form, or what we call the state form. There's not anything particularly unique about it. It's on our website. Many agencies will simply link to that, and that's fine. You can do that. But you must accept the state form if someone comes in with it. And then finally, we ask that you let us know here at the Office of Open Records who your arrow is. On our website, we have a searchable database where we list the arrows statewide, but we recognize that, people move on, they retire, they get promoted, and it's, our records aren't always up to date. So one of the takeaways from here today is check out our website, check the database, make sure your records are up to date. If not, there's a form there that you can fill out, email it to us on our website. We'll verify it and then update your records in a day or two. So that, and this is important because occasionally people will contact us. They want to know who the arrow is for XYZ borough, or if there's an appeal filed, we use this database as means as to identifying the person we need to reach out to notify them that we have an active appeal. And that becomes very important at that point. Okay, postings, yes, you're required to have postings physically within your facility, as well as a website. If you have a website, you're not required to have a website under the Right to Know law, but if you do, Right to Know information needs to be on there. It needs to list, first offhand, the contact information for the arrow. Think about this. Look at this from the citizen's perspective. You need to educate them as best as possible so that the process is not only smooth for them, but also smooth for you. All right. And that results in a seamless transaction where everybody's happy, the least amount of work that's necessary, and you can move on then with the other duties that you are concerned with. Have the contact information for the applicable appeals office. And in most cases, that's going to be the Pennsylvania Office of Open Records. You can simply put our website address on there. And it's because most of our processes are electronically driven through our website. So that's the easiest way to deal with appeals. You need to have a form available for them to fill out a request in case they don't have one. And then finally, list any of those local regulations, policies, and procedures that you may have locally that are unique to your specific municipality. Okay, but educate the requester. Let them know what the playing field looks like before they enter the game, so there's the least amount of surprises and things go as smoothly as possible from everybody's perspective. Okay, there are some things that you cannot do with the Right to Know law. And the first is that you cannot limit the number of records or the number of requests that a person submits within any specific period of time. You can't say, ma'am, I'm sorry, you've already filed 3 Right to Know requests this week. That's all we allow. If she's inclined to file a dozen requests, the law allows her to do that. Also, you cannot compel a person to disclose why they are filing the Right to Know request, why they want the records. Okay, you cannot force them to tell you that. Now, I'll go off script here for a moment. The greater majority of Right to Know requests are from people who are legitimately seeking records. But we also acknowledge that you will occasionally run across a person where, for whatever reason, the relationship between the municipality and that person has broken down. Maybe they don't like who was elected to council. Maybe they didn't like the size of their sewer bill last quarter, whatever. And they've decided they're going to be a pain in the neck. And one of the ways they're going to be a pain in the neck is to file a lot of frivolous Right to Know requests. Now, there are things that you can do to deal with that person. Typically, it's on the payment side of the Right to Know law. I would recommend that you sit in on our webinar dealing with payment issues, and we talk about this in greater detail, okay? But We acknowledge that those types of people are out there. However, in most cases, when I get a call or an email from somebody saying, hey, what can I do about this person? I usually ask the first question, do they owe you any money? And it is surprising, again, the degree of misunderstanding on the payment side of the right to know law, because a lot of people think the right to know law is free, and it's not. Okay, so off my soapbox, let's move on now to discussing other facets of this law. Let me get another sip of coffee. I like to describe the right to know process as an obstacle course. This obstacle course has two hurdles on it. And in front of the second hurdle, there are three hoops. So let's take a look at this real quick, and then we're going to talk about it in greater detail. Hurdle number one, we need to answer the question, is the request seeking records? Then we come up on hurdle number two, but hoop number one is, do any of the exemptions within the right to know law apply? And if so, are we going to invoke them? Hoop two is, are there any other laws that deem these records as confidential? Hoop three, does privilege apply? And then the hurdle, and ultimately the finish, is, are we saying this is a public record? Okay, question popped up. Are personal cell phones listed as a public record? Hold on here. Are personal cell phones listed as a public record if text may involve communications between township employees? The answer is yes, and you are, I think, one slide ahead of me. Calm down, slow down. Okay, and then another one. Can you provide an example of what a regulation, policy, or procedure of an agency would be? Okay, well, I just used that example. An agency can say that we will only accept right to know requests where the person is identifying themselves. Okay, that would be a local policy. Another one, the right to know law says that a request can be verbal. Okay, but since it uses that word can, not must, an agency can specify that we will only accept right to know requests that are in writing. We will not accept verbal requests. Okay, two quick examples. Hopefully that kind of sheds some light on your question there. Okay, let me move on. And we'll talk about this obstacle course in detail here. But first offhand, let's talk about receiving the request. Okay. Do exemptions need to be invoked? All right. Again, you folks are getting ahead of me, and that's okay. That shows you're paying attention and you're on your game here. But I promise you, I will be answering these questions. Okay. So the agency receives a request. The arrow has some duties that they have to do. All right. First is you note the date of the receipt on the written request, and it can be a date stamp. You can just write it in or whatever. This is important because a deadline has suddenly come into play, and that is because the agency now has 5 of their business days in which to provide an initial response to the request. Now, you receive the request today, tomorrow becomes your first business day, okay? And that's just a standard business practice there. And then the 5 business days, they're 5 of your business days. So it wouldn't include Saturday or Sunday. It wouldn't include a holiday. It would not include, a date where you're closed due to a weather emergency. It's days that you are open for business. And it's not unusual to get up into like the northern tier of Pennsylvania. And you would find small townships that may only be open 2, 3, sometimes 1 day a week. Okay. So let's just say it's 2 days a week. Well, hypothetically, you receive the request today. All right. So your next business day might be next Monday. All right. So you look at Monday, Tuesday, then you go to the following week, Monday, Tuesday, then you go to the third week, Monday. The end of that business day would be when your initial response is due, close of business. All right. What if you are a 24-hour agency, but administration is Monday through Friday? Good question. Typical example would be a police department, and I'm assuming that's what you're thinking about. You look at the days that your administrative office is open for business. You do not include weekends, holidays, emergency closings, and the like. It's when is the office accessible to the public? is your basic formula or basic frame of mind with that. Okay. So you've got these 5 business days that you need to provide an initial response. And that could be you're granting the request, you're denying the request, or it could be you need more time. And we'll talk about extensions here in a moment. You need to maintain a copy of this request. And it would be 30 days or until all appeals have been exhausted. Now, that's what the right to know law says. Okay. You hold on to all paperwork for 30 days or until all appeals have been exhausted. And when we say appeals, that could be through the Office of Open Records. For a local agency, it could get appealed further to your County Court of Common Pleas. It could then get appealed to the Pennsylvania Commonwealth Court, all the way up to the Pennsylvania Supreme Court. And this could take years, depending on the nature of the request and how far the parties are willing to appeal it. So you need to kind of be aware of what's going on here with all the appeals. Now, there is another law. It's called the Pennsylvania Municipal Records Act that applies to municipalities. It does not apply to school districts. And this would be under the Pennsylvania Municipal Records Act. They recommend you hold on to all right to know materials for 2 years or until all appeals have been exhausted. And then you can dispose of them as you would any other records on your record retention schedule. Okay, it's like, financial records, you keep 5 years or 7 years. Well, they're saying right to know, 2 years. All right, so I would recommend doing that. All right, there are some folks having trouble hearing me. It's on your end because we've got a lot of people signed in today. We've got over 50, and we've got a couple who are not hearing me. I would recommend logging off and logging in again. Okay, log off and logging in again. That usually takes care of the problem. Okay, yeah, it seems to be working for a couple folks here. All right, so moving on. Extensions. Yeah, let's say that you're really busy or for whatever reason, you cannot provide a final response within the 5 business day window. The right to know law allows the agency to take a 30 calendar day extension. Okay, note the difference. We've moved from business days to calendar days. Now it does include Saturday, Sunday. It does include holidays. It would include an emergency weather closing. All right, 30 calendar days. However, in order for the extension to be valid, there are some conditions that need to be met. First is that you need to invoke the extension within the 5 business day window. You can't wait until the 6th business day, suddenly realize, oh gosh, I forgot about this right to know request. Well, I'll just take an extension. Unfortunately, you've already denied the request by default when you failed to respond within the 5 business day window. It's legally what's known as a deemed denial. And the appeal window for the requester has now opened up due to your failure to respond in a timely manner. The second condition is that you need to notify the requester in writing that you're taking the extension. And if the request was submitted by email, you can respond by email. You need to provide a reason, and you go to section 902 of the law, and it actually lists 6 reasons that you can pick from. It could be, we keep these records off-site. It's going to take longer than 5 days to go dig them out. It could be, we want our solicitor to review this to make sure we're not giving out any records we're not supposed to. All right, then you provide a date as to when the requester can expect to get the final response. Usually that's on the 30th day of the extension. And then an estimate of any costs that the requester can expect to incur. And it is just an estimate. It's not a hard quote. You settle up on the exact amount when it comes time to actually provide the records. So you've got the 5 business days, and then the 30 calendar days get tacked on to the end, as they basically start on what would otherwise be the 6th business day. And that's how this system works. Now, I want to caution you, do not get into the habit of automatically invoking the 30 calendar days if you don't need to. All right. If you can respond, if you can provide a final response within the 5 business days, please do that. All right. Nothing upsets a requester more when they've submitted a right to know request for an obviously public record that would otherwise be readily available. And the first notice that they get from the agency is, oh, we're taking another 30 days. All right. It's just not right to do that. Now, if you have a valid reason for doing so because of your workload or whatever, I understand that. But please don't just develop an automatic policy that we're taking the 30 calendar days if you don't need to do that. Excuse me, need a sip of water. Okay, we're at that first hurdle. And the question that needs to be answered, if you recall, is it a record? Now, we're not saying, is it a public record? We're asking, is it a record? And we go to the right to know law itself, and we go to the definition section. And if you listen to these webinars when I'm doing them, I like to emphasize, if you want to understand how a law works, read the definitions because there's a lot of clarity in there. The right to know law has a definition of a record, and I'm paraphrasing here, but any information, regardless of its physical form or character, that documents a transaction or activity of an agency, et cetera, et cetera. Okay, key phrases in red here: documents a transaction or activity of an agency. What does that mean? Well, it means that the communication is about the business of the agency, the municipality, the school district, the authority, whatever. All right. And this is important because all day long we can generate communications that have nothing to do with the business of the city or the township or the borough or the school district or whatever. I hear a new restaurant's opened up downtown. Do you want to meet for lunch tomorrow? Or what do you guys think of the trades that are being made and the Eagles' chances of making the playoffs next season? Yeah, don't hold your breath with that one. Or I'm picking up a gallon of milk on the way home. Okay, all fairly typical communications, but yet have nothing to do with documenting a transaction or activity of an agency. Thus, under the right to know law, they are not considered records. And they are not accessible because you don't make it over the first hurdle. Okay, you're off the course and the request is denied. So when someone says, I want to see all of George's personal emails because George is a government employee, no, you're not going to get them because my personal emails have nothing to do with the running of the Office of Open Records. All right, so you don't have to worry about personal messages being disclosed through the right to know law process. Now, let me change this up a bit, and this will answer one of the questions that came up earlier. What if I I'll come up with a scenario here. Let's say I'm a township supervisor, and I'm sitting in my family room. I'm on my personal computer, and I'm on my personal Gmail account. And I send a message to one of my colleagues on the board, or let's just say I send it to all my colleagues on the board. I understand at tomorrow night's meeting, this proposal is coming up to revise an ordinance. I have some issues with the proposal. Here they are, and I'm leaning towards voting against it, but why don't you guys tell me what you think? Okay, now, first off, I just violated the Pennsylvania Sunshine Act, but more importantly, for purposes of our example here, I'm at home, I'm on my personal computer, personal Gmail account, but the message that I'm sending is documenting a transaction or activity of an agency. I'm exercising my authority as a supervisor. I'm talking about a matter that's before the board that will have an impact on the public that we serve, okay? Clearly, that is a record, even though it's on my personal device using my personal account. And that would also include my smartphone if I were using texting. All right. One of the very early Supreme Court decisions relative to the right to know law basically says that you cannot hide the public's business using personal devices or personal accounts. It's the content of the message that determines whether it's a record, not how it's sent or how it's generated or where it's stored. Okay? What types of personal information can we provide? Well, in Pennsylvania, even though the right to know law is one of the most transparent laws in the nation, we are fairly protective about personal information. It's going to depend who that person is and what types of records are being asked for. For the most part, take a look at the law, go to section 708B6, and it will identify personal identification information that can be withheld by the agency. Beyond that, there's also case law that protects stuff like your date of birth, your home address, and all that. As far as personal information goes, for someone who is not a public employee, it's fairly, I'm going to say strongly protected. If it is a public employee, most of the information related to that person's public employment is considered public information until you cross a line or come up against a line where the information truly is personal in nature, not having so much to do with their public employment, but stuff like their use of benefits, their use of leave, again, home addresses, an employee number, anything like that would be considered confidential and can be withheld by the agency. You've got to kind of look at, okay, what's related to their public employment versus what is more related to their personal life and personal identification information and their right to privacy, okay? But stuff like salaries, benefits overall, that kind of stuff, clearly, yeah, like we said earlier, and I'm assuming that you're new to the right to know law process. Public employee salaries are public information, okay? Very basic, well before the right to know law, all right? It's always been that way, okay? Yeah, brand spanking new. Okay, I understand. Welcome aboard, okay? Yeah. All right, so we're back to, all right, is it a record? And again, that phrase, documenting a transaction or activity of an agency. Is it about the business of the municipality, school district, or authority? If so, then it is a record and it makes it over this first hurdle. Okay, hopefully everyone understands that. Now we have to answer the question, is it a public record? And here's where things get complicated, because there are a lot of factors that come into play, and we've identified these three hoops that we're talking about. The first question we have to ask, or the next question, is do any exemptions apply within the right to know law? And if so, are we choosing to invoke them? Now, within the right to know law, you go to section 708B, and there is a list of 30 exemptions. An exemption is basically a definition of a type of record, and usually there's a couple paragraphs expounding on this definition. And a typical exemption could be, you know, you can withhold a record if by releasing it, it would put someone in physical harm, or health records for public employees. Any record that would divulge the address of a minor, okay, could be withheld. And you look at these exemptions and it's like, well, yeah, this all makes common sense. You know, I would not release something like this. And it covers an incredibly broad spectrum of records too, okay? So take a look at that section of the law. The law is available on our website under the Right to Know tab. It's not a very long law, and it's, for the most part, it's written in common English that you can easily understand. All right, but these exemptions are important. Okay, so that would be your first hoop. Are the records being requested covered by any of these exemptions? And then if so, are we choosing to invoke them? And I say that because the right to know law doesn't say you must withhold these records. Rather, it says you can withhold these records. And it's the agency decision to decide, are we going to invoke the exemption? Okay, and this is important because when you talk about meeting your legal obligation to prove that the record is not public, typically you would have to make your case by citing one of these exemptions. And I'll talk about that in a little more detail here coming up. Then we come up to the second hoop, which is pretty important because you need to identify, are there any federal or state statutes or a judge's order that makes these records non-public? While the right to know law gives the agency the discretion to choose whether or not to invoke the exemption, usually if there is another statute that says the record is confidential, that statute doesn't give the agency any discretion. It says you must withhold it, sometimes under penalty of law. For instance, we talked about public employee records. Let's talk about HIPAA, the Health Information Portability and Privacy Act, or Portability Privacy. Oh, Health Information Portability and Accountability Act. Yeah, there we go. Okay, HIPAA actually makes it illegal to release health records for anyone. Okay, so you also have like the Americans with Disabilities Act, the Family Medical Leave Act, all kinds of laws, all kinds of acronyms that say you don't release health records, okay? And there's usually penalties involved. So if you have another law that says these records are confidential, that removes any flexibility that you would otherwise have under the right to know law. Those laws would trump the right to know law. And thus you would not make it through the second hoop. You're off the obstacle course, request is denied. Now we move on to the third hoop, which we have to answer the question, is the record protected by privilege? Typically, this is attorney-client privilege. Any communication between an attorney and their client is confidential, where the attorney is, or the conversation involves sensitive information. So if you have a solicitor providing legal guidance and advice to a counsel, to a board, okay, that communication is protected by attorney-client privilege. It's part of the rules of evidence in Pennsylvania, supported by statute. Plus you go to section 305 of the right to know law, and it acknowledges attorney-client privilege. All right, so one of the areas that we get asked about a lot are invoices. What about the bills from our solicitor? Are those subject to right to know? The question is, it depends how detailed those bills are. If by looking at them you can discern legal strategy, then chances are they are protected by attorney-client privilege. However, if it's just the attorney saying, pardon me, for this month I'm charging you, 10 billable hours, then chances are that would not be protected under the right to know law, and it would be considered a public record. Another sip of water. Okay, so if it is protected by privilege, then again, you don't make it through that third hoop and it's off the course, okay? The request is denied. However, if it isn't protected by privilege, then you come to that second hurdle, and basically you're saying it is a public record, but we'll get there. So we're granting the request because we're saying it's a public record. Well, then you have to look at, is there any money involved here? Okay, does this person owe us money for us providing them records? And there's a couple things to keep in mind. Here's an important one. The agency is only required to provide the record in its current medium. What just happened? Hold on here. Something, I think I may have gone offline. Oh, no, I'm sorry. A weird screen popped up on here. I wasn't sure what it is. It looks like we're still online, though. Okay, so back to the presentation. Sorry about that. Okay, so you go to section 701 of the law, and I've kind of paraphrased it. What this refers to is electronic versus hard copy records. So let me give you an example. Let's say that our township approves building permits, and it's a completely paper-driven process. Someone submits the application, our codes enforcement officer reviews it, whatever. We issue an approval, and everything goes into a file folder in a file cabinet. Okay, but then you get a right to know request, and it comes through by email, and the person says, I would like a copy of this building permit, and I would like it sent to me electronically. Okay, so they do that, number one, because it's convenient. Number two, because it's free. You can't charge for electronic records. All right. Well, because the record is not electronic, the agency is under no obligation to convert it from one medium, electronic, to the other, hard copy. So your response would be, we do have this record, but it's hard copy. We're more than happy to make you a paper copy. And in so doing, we're going to charge you up to 25 cents a page, consistent with the right to know law fee schedule. You are not under any obligation to scan that record in, because that would be converting it from hard copy to electronic. Now, you can scan it in at your discretion, but remember, you cannot charge for electronic records. Okay, so that's how that works. Now, let's say someone requests to inspect records. Under the right to know law, you can request copies, or you can request to actually come in and inspect the record. If they do so, first offhand, the agency's in the driver's seat. They can choose when during normal business hours it's convenient for this person to come in. You can supervise the inspection to make sure that they don't alter or destroy or steal any records. However, if they pull out a cell phone camera and take a picture, they're allowed to. They're allowed to make pictures, their own copies of public records. Now, an agency cannot charge for labor, you cannot charge a redaction fee, or you cannot charge for any legal review. That's simply considered the cost of doing business under the right to know law process. You can only charge what are considered actual costs or pass-through costs. A good example of a pass-through cost would be postage. Someone requests hard copies, you can charge them, for the copies themselves, and then you put them on your postage meter because they want them mailed. It's $3.15, so you can add the $3.15 onto the invoice. Okay, question has popped up. What if all permits are scanned and sent to other agencies during the process? Well, because you already have electronic versions of the permits, you're obligated to provide them electronically. Remember, you're only required to provide them in the medium, the record in the current medium. Well, because your current medium is electronic, if they request electronic versions, you would provide them with electronic versions, and you cannot charge for the electronic records. How do you get people to pay 25 cents? We're requiring for hard copy plus the postage, especially if they're from New Jersey. Do they have to pay first before we send? Bingo, yes. I cover that in the payment side. The right to know law, paraphrasing again, says that records are provided upon payment. So yes, you can ask that, or you can require that they provide payment, and then you send the records. I don't want to get too far in the weeds here, but all these deadlines in the right to know law refer to when you provide a response, not when you provide the actual records. So you can grant a request by saying, we are providing you with these records, send us a check, and when your check clears, then we will mail the records to you, or you can come pick them up, or we will do whatever, okay? The deadlines are for when you provide the response, not when you provide the actual records. It's just presumed that within a reasonable period of time, after the payment is cleared, you would you would then send the records. Okay, that's how that works. Can I ask what the only select participants can unmute means? I cannot hear this webinar at all. Okay, I don't, okay, obviously she can't hear me, and I'll just have to wait to answer that. I don't know why she's having a problem. Okay, so if they ask to send an electronic copy of the hard copy, what is a good response back? Okay, well, it's kind of like I said earlier. You let them know you have the hard copies available, and that they're going to cost you, up to 25 cents a page. All right, that's how that would work. Okay, so moving on for payment issues. No surprises. It's kind of been my theme here. Let the requester know. You receive a request, you do a quick estimate of what you think it's going to cost, and then I recommend picking up the phone or sending them an email back. Hey, we think this is going to cost about $30. Are you okay with that? Before you begin really working on the response. All right. If they may balk at that and say, no, I'm not willing to pay that. I thought this was all free. All right. Well, that way you save yourself a lot of time and copy expense, and you don't get stiffed for that $30 that they otherwise would have owed you. Okay. Communication is good. All right. And then, like I was talking about with the previous slide, ideally it's a mutual exchange. Here are your records. Here's the money. But like I said, the law says payment is due first, and you can come up, with your own invoicing system to ensure that you have payment in hand before you actually provide the copies. Now, let's say you get a really big right to know request, and it's legitimate, okay? And you do your estimate, and it's going to exceed $100. Well, the right to know law has this provision in it where you can demand that the person pay up front if it appears the cost is going to exceed $100. I like to view it as a security deposit. This way, the agency's not on the hook for a really big expense that the person might balk at because you've got their security deposit for the amount in excess of $100. Then you've got another situation where it's called record discard, and this is outlined in Section 905. The scenario would be someone submits a right to know request for hard copy records. Okay, you grant the request, and you've had communication with them, and you agree that, okay, you're going to come in and pick them up, and they're going to pay then. All right. Well, under the right to know law, you're obligated to hold on to those records for 60 days, 60 calendar days. If at the end of those 60 calendar days, the 2 months, that person hasn't come into the office to pick up their records, you can discard them. You can shred them. You can throw them out, whatever you need to do, because you've met all of your legal obligations. And let's use this $30 figure again. Let's say that the response costs $30. Well, on the 61st day, your requester shows up and they're all smiles. Okay. Hey, I'm here to pick up my records. Well, they're out of luck, and they're out of luck on a couple different levels here. First offhand, they still owe you the money because you did everything you were required to do. Then let's say they still want the records. Well, they have to submit a second right to know request. And chances are it's going to cost them another $30. But you don't have to process that second request until they've settled up payment for the first one, the $30. And let's just say that they no longer want the original records, but they submit a right to know request for a completely new set of records. Well, again, you don't have to process that second request until they have settled up the debt for the earlier request. So if there are any outstanding fees, you don't have to process any further right to know requests for this individual. Just remember, though, that it is considered a denial, and they can appeal that. So you want to make sure all your I's are dotted, all your T's are crossed as far as all your communication. Make sure that everything's been calculated correctly and you've done everything consistent with how the right to know law works. And chances are that an appeals officer will agree with the agency position, provided, like I said, all your paperwork is in order. Okay, so that's how that works. Okay, moving on here. Let's say that they didn't make it through the obstacle course, that they have decided, or that the agency has decided that they do have grounds for denial. All right, the question has popped up here. What happens if they state they never received the package after they pay? Oh my. Well, I don't know. I mean, that's something you're going to have to work out between the requester and the agency. Maybe send them another copy. Um, if it's being mailed, perhaps you want to use return receipt, that kind of stuff. That's really outside of the purview of the right to know law. You're required to provide them with the records. So I would make sure that you have proof that the records were delivered to the requester. Okay. I think that's what I would do in that case. And I think that's probably what most agencies do. All right. So you've decided that for whatever reason, you're denying the right to know request. Okay, we're not granting it, so there's no payment involved. We're denying it. So there is a format that you use in the letter that you send to the person where you're notifying them of the denial. The first is that you describe the records that you believe are being requested. Okay, seems like a no-brainer, but sometimes, you want to make sure that there is a clear understanding between the parties. This is our understanding of what it is you're requesting. Put it in your own words. Okay, and then you state the reason why you are denying the request. And remember, this is where the rubber hits the road because the agency bears the burden of proving why the record is not public. So you would state, we believe that this record falls within this exemption, and you make that connection between the records being requested and why they fall within this exemption. And typically, it would be one of those exemptions within the right to know law. Maybe it's one of those other laws. Maybe it's covered by attorney-client privilege, okay? Make your case. And then you put the contact information for the arrow. Remember, this is the person legally responsible for responding to the request. So you need to say who this person is, who you are. Then you put the date of the response. This is important because another deadline kicks in on the date of the response. And then you notify the person the procedure to file an appeal with the applicable appeals office. Usually it's the Office of Open Records. I'm going to say in 95% of the cases, the appeal comes to the Office of Open Records. Okay, so let's talk about appeals. Once the agency denies or deems denies, if they forget to respond, the appeal window opens and the requester now has 15 business days of, our business days here at the Office of Open Records to file their appeal. Okay, and it's based on that date of the response. Now, most appeals are filed online on our website. It's a fairly easy process to do that, and it feeds into our docketing system. So when we receive an appeal, we look for 4 elements. We need a copy of the original request. We need a copy of the agency's response, provided they gave you one. The person needs to provide a statement, and usually this is part of the appeal filing process as to why they believe the records are public, and then why they believe the agency's response is incorrect. Why they believe their grounds for denial are inappropriate. Okay. Yes, it's being recorded. And as I said at the beginning of the presentation, send us a flash drive. All right. Okay, so if any of these 4 elements are not present, we will send out a notice of deficiency, and the person usually has a day or 2 to correct the deficiency. If they fail to do so, the case gets dismissed. However, if all the elements are present, it gets docketed as an active appeal. We will send out a notification to all the parties that we have an active appeal. It's what we call a docketing package, and usually it's by email sent to the agency open records officer. And it includes all of the instructions, what this is about, what you need to do, a docketing number, who the appeals officer is, all the deadlines, everything gets shared between the parties. Now, here might be the most important thing that you hear as a new agency open records officer, or maybe even one who's been around for a while. If you get notified of an active appeal from our office, do not walk to your solicitor and let them know. Okay, everything I've described up to this point is what we'll call an administrative process. Once an appeal gets filed, it is a legal process. The Supreme Court of Pennsylvania has identified the Office of Open Records as an independent administrative tribunal, or quasi-judicial tribunal, I'm sorry. It basically means we're a court, okay? Everything must be done per legal standards, including the language that's used, the forms that are filed, et cetera, okay? Do not try to respond to an appeal on your own, all right? Because you're not expected to know how to. Your solicitor, on the other hand, is. Give it to your solicitor. They've got pretty tight deadlines for getting their filings in. Don't put them out there. I'll just repeat myself. Talk to your solicitor right away. Okay? So the appeal gets filed. The product of an appeal is what's called a final determination. That's the decision from our office. These are legally binding final orders. Okay? They're issued within 30, lately 60 days of the receipt of an appeal due to the extensions. And you can find them on Westlaw, Lexis, and they're also on our website in a searchable database. Everything we've issued since 2010, it's like 30,000 decisions and counting. You can go in and search on your municipality. You can search on names. You can search on legal issues. You can just simply put in a random text string and see how many decisions we've ruled on the subject that you put in. Okay. Fairly useful tool to use. Okay, there also is the option of mediation, where if you don't want to go through the normal process, when the person files the appeal, we ask them, are you interested in mediation at all? When we send out the appeal packet, we ask the agency, would you be interested in mediation? If both parties are, we have trained mediators on our staff, where sometimes you just get the impression that everything can be solved with a conference call. And that's what we'll do. We've got all the parties on the phone line, get them talking to each other, and more often than not, the parties are able to agree, and that solves the issue. If they're not able to agree, no harm, no foul. The case gets removed from mediation, gets put back into the normal appeals process. Okay, but mediation is a tool that's available for you if you want to consider it. And then our decisions can be appealed, as I alluded to earlier, to higher level courts. If you're dealing with a local agency, it goes to your county court of common pleas. The paperwork must be filed within 30 days of the issuance of the final determination. The Office of Open Records is not a party to the dispute. Okay, the dispute is still between the requester and the agency. Either party can appeal our decision. Okay, so it goes to the Court of Common Pleas. If you're dealing with a state agency, it goes directly to the Pennsylvania Commonwealth Court. Okay, but our decision is legally binding. The court must consider that as precedent and as part of the fact-gathering phase. Okay, so in deciding to deny a request, we could check previous appeals and see what has been done previously. Absolutely. Yeah, give yourself an extra donut there. That is a very good question that you've kind of answered yourself, and it is the correct answer. Yeah, take a look at our decisions. Go in and search on the issue, and it will help you out, okay, in deciding the appropriate course of action. Okay, so we get served with the notice of appeal. Because we will either monitor the case or decide to participate in it at some level if we believe there's some important point of law that needs to be addressed. Okay, but our decisions can periodically be appealed to a higher level court. Okay, so we're at the end of the presentation. If you have any further questions, now's the time to get them in. Or, like I said, feel free to reach out to the office later. But before we conclude, I want to direct you to our website. I've referred to it a couple times here. I'm just going to say this. Those of you who have been on other webinars know what I'm about to say. This is the best government website you will ever encounter. It is updated 6 days a week with new information, new decisions about the Right to Know law and Pennsylvania's Sunshine Act, which governs open meetings. Like I said, decisions, we have guides on the website for citizens, for agencies. If you happen to be an agency open records officer, there's an arrow guide on there, 78 pages long, of all kinds of helpful information that you can use that will help you with your job. There's a training page on there where we have the training calendar that you can sign up. Well, you don't even need to sign up for these webinars. You just click on the link and you're in. Okay. And if you're a real geek about government transparency, you can sign up for our Twitter feed, where every morning at 7 a.m. we will wake you up with a tweet that includes all the latest information on government transparency, on the right to know law, court decisions, and the like. Finally, if you do have any of those questions, please reach out to our office all day long. We talk to citizens, we talk to agency staff, and we try and get you steered in the right direction. We cannot write requests for you. We cannot write responses for you. We cannot tell you how an appeals officer is going to rule, but we can kind of steer you in the right direction if it looks like the issue that you're dealing with is similar to one that we've already dealt with. Just like was asked, we can show you final determinations and court decisions very similar to what you're dealing with, so that you have an idea, okay, this is what case law says, so I'm going to use this as the basis for meeting my legal obligation in denying this right to know request. Or maybe deciding, well, yeah, public salaries clearly are public information, so I'm gonna grant this request for all of our salaries, that kind of information. Okay. So, not seeing any further questions here, I'm getting ready to sign off. I'm sorry that a couple of you had difficulty with the sound today, but hopefully you were able to work it out. And we'll see you hopefully at some future webinars. Take care. We're signing off.